according to the Companies Act 2013, okay, the organization or the company is different, the ownership is different. Before the introduction of Companies Act 2013 in Companies Act 1956, there was no provision for one-person company. A private company is a company that is privately owned by a small group of individuals. The shareholders are liable only for the unpaid value of the shares that they had purchased from the organization, not more than the value of the shares. Hello everyone, a warm welcome to one and all. I am Mr. Hemant Kumar from the Department of Commerce and Management, Vidhyaashram First Grade College, MYSURU, the Temple of Excellence. In today's session, we are going with the subject Company Law and Practice. In the same way, as I explained in the previous session, the route map, how exactly we are going step by step, the syllabus pattern. Okay, so among them, this is the first unit, okay, of a company law and practice. It's going to say about the introduction of a company. So here we will be having a brief introduction about a company, what exactly the company is, and which are all the things that is present in a company. Okay, so here in this subject, okay, this is session 1 of unit 1. That is for second semester BCom students, that is company law and practice. This is the agenda of today's session. We are going with the topic of meaning and definition of a company, followed by features or characteristics of a company, and also by types of company. Okay, so meaning of a company. Here we get to know what exactly the company is. A company is a legal entity that is created by law. Okay, so the company is been created by law, not been created in the natural process. Okay, so it is a legal entity which has been created by law legally to carry on business, earn profit, and achieve the common objective. So what will be the common objective while establishing a company? Making profit will be the common objectives. Okay, so in other words, a group of people gather in the intention of making profit with the common intention, that we call it as a company. Okay, so a company is a legal entity which has been created by law. Okay, so that has legally been formulated. Carry on business. So they are going to form the company in the intention of business. Earn profit. It is going to earn profit. Why we are going to make any kind of business? To earn the profit. And achieve common objectives. There are desired objectives of the organization. The objective of one organization is different from another organization. Okay, ultimately we are going to go through these all things. It is formed when a group of people come together and register under Companies Act. Okay, so if a group of people, okay, so intended to come together and register under Companies Act, we call it as a company. So if it is not registered under a Companies Act, we won't call it as a company. Okay, so even there is a Cooperative Society Act as well. Okay, so there are a number of act, Factories Act. Okay, so we won't consider those things as a company. If it is registered under a Companies Act, whether it is a 1956 or 2013, we call it as a company. So which gives it a legal existence that is separate from its members or shareholder, that we call it as a separate legal entity. The business is separate, ownership is separate. Okay, so that we call it as a legal entity. It is a characteristic of a company. Being a separate legal entity, a company can own property. Okay, so being a separate legal entity, okay, so the company can own property in its own name. If a company want any assets, okay, so whether it is a land and building, furnitures and fixtures, plant and machinery, it can purchase it in its own name. Okay, so own property. Enter into a contract. So even the company have a complete right to enter into a contract. So that is the reason why we call it as a separate legal entity. Okay, and in the same way, it is a artificial person. Okay, so as come into existence by the artificial process, we call it as a artificial person according to the law. First thing. Second thing, as a natural person, it can also buy a property in its own name, and also it can enter into a contract in its own name, followed by borrow money by the stakeholders, shareholders, debenture holders, sue and be sued in its own name. Okay, so it have the complete right to sue against other person or other entity, and also get sued by other entity or other person. We call it as a company. Independent of personal affairs of its owners. Okay, it is independent from the personal affair of its owner. As I give you the example, okay, so the owner is different, entity is different. Okay, so if any mistake did by the owner of the company, they are going to catch hold the owner, not the company. The company will keep on going. Even there is a death or the insolvency of the owner of the company, okay, so it keep on going. Okay, so because it is have a special feature called perpetual succession, okay, that we are going to learn in the characteristics of a company. Here there are a few definitions that has been given by the management thinker. According to Justice James, a company is an association of persons united for a common object. Okay, so according to him, it is a association where the people of the common objective, they are going to form a company. So it is true actually, okay, because all the people will be having a common mindset or the common objective. Okay, so that is hitting the goals of the organization or forming an organization for the future profits. Next one, according to Kimball and Kimball, a corporation is by nature an artificial person created or authorized by the legal structure for some specific purpose. Okay, so according to him, it is a artificial person, okay, which has been created for some purpose. Okay, so there are a number of companies which have a different vision policy and mission policy. The objectives of the company is completely different. The working of the company is completely different. The way how they are going to present itself, it is completely different. Okay, so one company is different from, unique from another company. Here we are going with a few characteristics of a company which is being defined by Companies Act 2013. Okay, so an artificial person created by law. Okay, so see what happens. This company is an artificial person. It is not a natural person. Okay, so it is going to say that it is a artificial person, not a natural person. Say what happened? Natural persons are going to come out by the natural process, but the artificial persons, it is going to formed by the law. Okay, so we call it as a artificial person. And in the same way, why we call or consider it as a person? Why we consider the companies as a person? Because it have a similar characteristic as a natural person. Why? How? A natural person can purchase a property in his own name. Okay, I being a natural person, I can purchase any of the property in my own name. Even the company can purchase a property in its own name. And in the same way, even I, as a natural person, okay, so I can enter into any kind of agreements and contracts. Even a company as an artificial person, it can enter into any kind of a contract, any kind of the agreements. Okay, so and in the same way, even I as a natural person, I can borrow the money from the people. Even the company is going to borrow the money from the people, from its shareholders, from its stakeholders. Okay, so now, so and in the same way, as a natural person, I have a complete right to sue and get sued. If I want to file a case against some other person or some other entity, I have a complete right. Okay, so and in the same way, the legal entity also, okay, it have the right to sue against another entity. It have the right again to sue against another person. Okay, in terms of any kind of a malpractice, if there is anything wrong which has happened. Okay, so if the company get cheated, okay, it have the complete right to sue and also get sued by other person. It may be a person or the legal entity. We call it as a artificial person. Okay, next one is separate legal entity. Separate legal entity, the characteristic is going to well define the place of the organization. It means that according to the Companies Act 2013, okay, the organization or the company is different, the ownership is different. The thing which is going to happen on the company does not affect the ownership. Ownership in his personal life, whatever the thing it is going to happen, does not affect the company. Say for example, if any malpractice happen in a company, if there is any problem that had happened in a company, okay, so they are going to take the necessary action on the company but not on the owner of the company. Okay, owner of the company, which is going to safeguard the rights of the ownership, okay, which is going to safeguard the owners of the company. If any wrong thing that is did by the owner of the company does not affect the functionality of the company. In terms of death or insolvency of the owner also, it does not affect the functionality of the company. Okay, so that we call it as a separate legal entity. Ownership is separate, company or the entity is separate. Next one, perpetual succession. Perpetual succession, clearly it is going to say about the ownership of the company. It is going to say, okay, there is a mantra of this perpetual succession. Okay, men will come, men may go, but it does not affect the operations of the organization. Means if a owner of the organization may die, but the company keep on running. If a owner of the organization may become insolvent, but the company keep on running, that kind of a characteristic we call it as a perpetual succession. Best example is the Tata company. Ratan Tata had expired. Okay, so but also still today Tata company, that is Tata group of companies, making a huge profit. It running its operation in a very smooth manner. Why? Because of this characteristics. The owner means the men may come, the men may go, but it does not affect the operations of the company. Okay, that we call it as a perpetual succession. Common seal. Each and every company have its own common seal. As we know, the name of the entity, it differs from another entity. Okay, the name of the company, it is different from another companies. In the same way, the logo of the company also is different from another companies. Okay, we may see a number of companies with different logos and different names, right? In the same way, each and every company have its own common seal, which will be considered while making agreement with other people. Yes or no? So it is going to say about the authenticity of the document. If a company is going to enter into any kind of the project, any kind of the contract, any kind of the agreement, this seal of the company is mandatory. If there is no sealing of the company is present on the documentation, it will be not considered as legal. It is going to ensure about the authenticity of the document or a contract. So this seal is mandatory. Okay, so each and every company must have its own common seal. To enter into a contract, to enter into an agreement, to make any kind of the things or the activities, this common seal is mandatory. Limited liability. Limited liability. So to whom the liability is limited? For the shareholders. It is a special feature that is being given by under the Companies Act, which is going to safeguard the property of the shareholders. Say what happens? Okay, so the shareholders are only liable to pay the agreed proportion of amount. Okay, not more than the amount which they had agreed for. Means, I mean to say, the shareholders are liable only for the unpaid value of the shares that they had purchased from the organization, not more than the value of the shares. Say for example, a shareholder had purchased 50 shares which is worth of 50,000. Let me say at the beginning he had paid 20,000. Okay, so still he have to pay 30,000. Okay, so the moment he paid 20,000, he is liable only to pay this 30,000 of due amount which he had agreed for. If a company get a loss, if there is any bad news regarding the company, okay, so if a company shares value come down, okay, he is not liable to pay more than his agreed proportion of amount. He is liable only for the payment of the due amount that he had agreed to pay for. Okay, so that we call it as a limited liability. There is a kind of company, okay, so that we call it as a unlimited company, where the shareholder should sell his complete property to fulfill the debts of the company. Okay, but this kind of a feature is going to safeguard the property, safeguard the wealth, safeguard the assets of the shareholder. That we call it as a limited liability. Next one, transferability of shares. Transferability of shares. Okay, so here, according to Companies Act 2013, the shares of the companies can be easily transferred from one person to another person, easily. Okay, but when it comes in terms of a private company, the shares cannot be easily transferred from one person to another person. Hence, there is a restrictions regarding the transfer of shares when it comes in terms of only in private company, not in a public company. Public company, he can transfer his complete share to another person. Okay, so but when it comes in terms of a private company, okay, there are certain restrictions that is put by Companies Act 2013. Limitation of work. Limitation of work. So the company can only work within the scope of memorandum of association, whatever the permission that is been taken by the company while registering the company. Okay, so only that work that the company can do. I will just give you the best example. Okay, so we are already aware of a Tata group of companies. Okay, so we have a n number of companies under Tata group. Okay, so it may be Tata Consultancy Service, which is completely IT based company. The Tata Motors, completely product based company, that is automobile manufacturer, followed by Tata Steels, steel business, Tata gold business. Okay, so Tata Sampann, grocery related. Okay, see what happens, according to the memorandum of association of Tata Consultancy Services, it should engage only in IT things, IT based things. It should not deal with any of the activities. It should not deal with any kind of the automobiles. It should not deal any kind of gold business. It should not deal any kind of other activity rather than the activity that is being mentioned in memorandum of association. Right? Okay. So that we call it as a limitation of work. There is a limitation of work. They are supposed to do only the work that they had mentioned in memorandum of association while registering the company. They are supposed to do the work which they had got the license only for. Tata Consultancy Service, they have to take care only of the consultancy services, not take care of the any kind of manufacturing things. They cannot manufacture any automobile or any products. When it comes in terms of Tata Motors, it should manufacture only automobiles. As per this thing, limitation of work, it is only limited to manufacture automobile. Tata Sampann, it is only limited only to manufacture and facilitate the groceries to the society. You do not have any right to enter into a gold business or a silver business. Okay, so that feature is going to give the complete well-defined objective of the company, that is limitation of work. Voluntary association for profit. A company is a voluntary association for profit. Okay, so nobody is going to beg you to invest on my company. Please do purchase the share of my company. Nobody is going to scare you people. If you won't purchase the share of my company, I am going to fire you out. Done? It is a voluntary association. If you are interested, if you have a confidence saying that by investing on this company, I can make the profit, you can enter the contract. You can purchase the shares. If you are not interested, you can just skip it. Okay. Hence, it is a voluntary association. Okay. So, how exactly it is going to work in the current generation? If people are interested in that particular company, what kind of a sector it is, what exactly the activity that is done by that particular sector, and what exactly the profit that has been earned by that company, what is the dividend sharing ratio? Okay, so these are all the things that is being looked over by the shareholders while investing on the company. They make sure that they will be having a good return on investment out of their investment. Okay, so that we call it as a voluntary association of profit, to make a profit. I repeat this concept because I'm just going to brief this concept because it is a repeated concept for your final exam. They may ask this question for 10 marks. Okay, so an artificial person created by law, because as a natural person, it can purchase the property in its own name, it can enter into a contract in its own name, and in the same way, it can sue and get sued. Okay. And in the same way, separate legal entity. It is separate from its ownership. Perpetual succession. Men may come, men may go, but the company keep on going. Common seal. Each and every company have to make its own common seal, which is considered as a legality and authenticity regarding while entering the contract. Limited liability. Okay. To safeguard the rights of the shareholder, this concept had introduced. It is saying about the limitation regarding the liability of a shareholder. Transferability of shares. Okay, transferability of shares. So, easily we can transfer the share except the public company. In public company, there are certain restrictions put on the shareholder to transfer the shares. Limitation of work. So, he is liable only for the work that he had taken or mentioned in the memorandum of association. voluntary association for making profit. If I want to make a profit, I can enter. If not, I can take the exit. Nobody is going to force me to stay in the company itself or come and invest on the particular company. Moving forward, so here we step into types of a company. Okay, so the company has been classified into many categories based on its functionality, based on its speciality. Okay, so here the first one is a one-person company. This one-person company is a new concept under a Companies Act 2013. Before the introduction of Companies Act 2013 in Companies Act 1956, there was no provision for one-person company. Okay, so here it is a feature, or it is a new concept that has been bought by the Companies Act 2013. One person company, the name itself, it is going to say that a single person can take care of its own business without interruption of anybody. He need not wait for the decision of other people. Voluntarily he can take any kind of decision in his own organization. Okay, so that we call it as a one person company. Even this one person company is also a separate legal entity. Being a single owner also, whatever the mistake that is going to happen in the company does not affect the ownership. If ownership, any kind of a mistake that is being done by the owner of the company does not affect the functionality of the company. Okay, it is a separate legal entity. And also here in a one person company, so the name, what exactly the minds of the people is, name is going to say that it is a one-person company. What if in terms of a death or the insolvency of a owner of the company? Absolutely, you are right. This company have a special feature called perpetual succession. If a owner of the company get expired also, if a owner of the company get insolvent, also this company keep on running its operations smoothly, because while registering the companies under Companies Act 2013, he have to nominate a person who is responsible for the company after his time. In terms of death or the insolvency of the ownership, the company come in the hands of that nominee. He can take any of the decision. Either he can dissolve the company or he can continue the company. The decision in the hands of the nominee. Okay, so that is a special feature or the speciality of a one-person company that I can say. Done. Next one is a company limited by shares. Company limited by shares. See what happens. This company limited by shares, we call it as a limited company. Limited liability of the shareholder. It is going to project the or safeguard the liability of the shareholder. Liability of the shareholder. As I gave you the example, the shareholders are liable only for the agreed proportion of amount he had agreed for. Only for the pending amount that he is liable for. As I give you the example, if a shareholder purchase 10,000 worth of shares, okay, 10,000 worth of shares. At the beginning, he had paid only 5,000 and there is a 5,000 due amount. He is liable only for 5,000 due amount, not more than the 5,000 of due amount. When it comes in terms of a company limited by shares, it is going to safeguard the wealth of the, means in terms of any loss of the company, he should not pay a single rupee from his hand. He is liable only to pay the agreed proportion of amount, the worth of the share that he's been purchased by the shareholder. Okay, so that we call it as a company limited by shares. Next one is company limited by guarantee. Company limited by guarantee. Okay, so this kind of the companies, okay, so usually run with the non-profit motive. It may be NGOs and NPOs, the charitable institutions. We call it as a company limited by guarantee. Okay, so usually this kind of the organization also register under Companies Act 2013, but the difference is all the companies that I had listed is going to make the profit. This group of company does not make any kind of a profit. This kind of the companies are established to make a charity for the well-being of the society, to serve the society, to serve the people one who is really in need. Okay, so that kind of a company we call it as a company limited by guarantee. In this company limited by guarantee also there is a profit. If any economic activity which is going to happen under this company, okay, so the shareholders will be not sharing the profit that is been earned by the company, that they are going to distribute among the activities of the company, expenses of the company. They won't keep any kind of the profit. No profit will be shared among the shareholders of the company. Okay, so only the volunteer people, one who are going to take the initiative, they can form this company for the charity purpose. Unlimited company. Okay, unlimited company is opposite for the limited company, that is company limited by shares. In the company limited by shares, it is going to safeguard the rights of the shareholders. But here, unlimited company is a company which does not safeguard the wealth of the shareholders. Say for example, in terms of an unlimited company, the shareholder had hold a share which is worth of 10,000 rupees. He had initially paid 5,000 rupees, is liable only to pay 5,000 rupees. Done. But some problem had happened to the company. It affected the functionality of the company. The complete working condition had stopped in the company. The company get into a complete loss. He is liable to pay the complete entire loss amount. All the shareholders are liable to pay the loss amount in their hands. Done. Okay, so that kind of a company we call it as an unlimited company. Okay, so usually this kind of a companies are very rare in today's generation, and in the same way this kind of the companies are formed only by the trusted people, okay, and in family members. Okay, this kind of the companies will be formed by this group of people. Holding company and subsidiary company. Holding company and subsidiary company. Holding company is a company which hold maximum amount of share in its hand. Maximum amount of share means it is more than 50% of shares. More than 50% of the net worth of the company, that we call it as a holding company. Okay, subsidiary company, the company which is going to hold less than 50% of share. Say for example, there is a holding company which hold around 51% of share, that is more than 50%. Okay, that is a holding company. There is a subsidiary of this holding company which hold around 49% of shares. Okay, that we call it as a subsidiary. Means all the decisions, majority of the decisions will be given by the holding company, should be followed by the subsidiary company. All the rules will be made by the holding company, should followed by the subsidiary company. Okay, so that kind of a company we call it as a holding company. The company which hold more than 50% of its share, we call it as a holding company. The company which hold less than 50% of its value, we call it as a subsidiary company. So more than 50% maybe also become 99% as well. Less than 49% also may become 1% as well. If it hold 1% also, we call it as a subsidiary. Okay, so that we call it as a holding company and subsidiary company. Government company. If a state or the central government hold more than 50% of the shares of a particular sector, we call it as a government company. Best example is Indian Railway, KSRTC, BMTC, Maimul, Nandini. These are the government companies. Associate company. The one company is associated with another company to share its profit and losses and the agreed proportion. We call it as a associate company. So these are the two companies which we must know about. Okay, so one is a private company, second one is a public company. These are the two important companies which we must know. So also I had mentioned the difference between the public company and the private company as well. Okay, so when it comes in terms of a private company is a company that is privately owned by a small group of individuals. It is privately owned by the small group of individuals. Because it is a private company. Okay, so not large number of the people can own the private company. Its shares are not offered to a general public. Means a private group of people that they are going to undergo under a business activity, we call it as a private company. And our ownership is usually limited to family members, friends, or close group of investors. Okay, only a limited private group of people, they are going to formulate a company. We call that kind of a company as a private company. The name itself, it is going to represent or highlight the privacy, private. Okay, so that we call it as a private company. And a public company. Okay, so they are going to offer the shares. They are going to call the general public to invest on the company. That we call it as a public company. So that is different from a private company. A public company is a company that can raise capital from the general public. It can raise the capital by the general public by offering shares or debentures. By issuing shares and debentures, its shares are freely transferable and can be listed on stock exchange. Okay, so that is a special feature of a public company. This private company shares cannot be listed under the National Stock Exchange or Bombay Stock Exchange. Okay, so these people cannot offer the shares to the general public. Whatever the investment is there by that group of people, private group of people, should invest the complete capital towards that particular business. Those are the people who are going to share the profits and losses equally. Okay, that kind of a company we call it as a private company, followed by a public company. Public company is opposite for the private company. Okay, so it is going to offer the shares to the public listed on the National Stock Exchange. It is going to list under SEBI. Done. So that kind of a company we call it as a public company. Here, just I had collected few information regarding the difference between the public company and the private company. So this is a private company and this is a public company. When it comes in terms of a private company, minimum 2 and maximum 200 members. If there is minimum of 2 members, they can easily start a private company, but not in terms of a public company. Because in terms of public company, there must be huge capital. Okay, so a big kind of a business that they are going to afford for. Okay, so when it comes in terms of a public company, okay, minimum of 7 members, no maximum limit. Okay, so unlimited members can participate in this company. So we can easily purchase the shares of this public company, but not the private company, because they are not going to offer for the general public. Done. Next one is, shares cannot be freely transferred, usually restricted. There are certain restrictions that is being put by the law under this company. Okay, which one? The private company. Say what happens when it comes in terms of a public company, shares are freely transferred, can be listed on the stock exchange. For example, I had purchased the shares of this public company, 100 shares of the public company. Easily I can sell the share whenever it is not needed. But in terms of a private company, only few number of shares I can transfer to another person, not completely the 100 shares. It is a special feature of a private company. Next one is, cannot invite public to subscribe to shares or debentures. So there is no opportunity for public for the investment when it comes in terms of a private company. Here there is an opportunity for the public. Okay, so it is going to offer the shares to the general public, can raise the capital from the public via IPOs, that is initial public offerings, public subscription. Okay, so while listing on SEBI, okay, so through IPO that they are going to list their company. After that, we can before they launch the IPO itself, we can purchase the shares of the company. Okay, after launching of IPO, we can purchase the shares of the company using the brokering applications. Minimum 2 directors should be present in terms of a private company. When coming in terms of a public company, there must be minimum of 3 directors. Must send the name of the private company should end with the name private limited. The name of the public company should end with the name limited. Okay, so these are the difference between a public company and the private company. In the next session, we are going with unit 2. It's completely regarding a formation of companies. Okay, it is going to say about the formalities for formation of a company. Thank you.